Great. Thank you. The Court of Appeals is now in session.
Good morning. Welcome to the virtual Court of Appeals. My name's Judge Diana Hagan, and with me today are Judge Ryan Harris and Judge Greg Orm. We are hearing argument this morning in Re D.A.T. 2019-0986. Let me first ask if counsel would please enter their appearances for the record, starting with the appellant.
Jack McIntyre on behalf of Appellant D.A.T., Your Honors.
Welcome, Mr. McIntyre.
Chris Leonard for the state.
Welcome, Ms. Leonard. Very nice to have you both here. I see that the clock is set at 10 minutes. Is that because you have reserved 5 minutes for rebuttal, Mr. McIntyre?
It is, Your Honor.
All right, wonderful. If we keep you over that, asking questions, we will not count that against your rebuttal time. If you simply decide that you want to use some of your rebuttal time in your initial presentation, you're certainly welcome to do that. And Ms. Collins will just continue having the clock count down into the rebuttal time. What we would like to do during these arguments is, if you're not speaking, and the judges will do the same, we will mute our microphones so that we don't have an echo. When it's not your turn to speak at the podium, if you'll also turn off your video, and that way we can focus on the person who's speaking. If we have any technical problems, don't worry, we will pause the clock, we will get them sorted out, and we'll make sure that we provide you with all the time you need to make your argument. When the judges want to ask a question, generally we give you a little wave. You may not always be looking at the screen, and we're notoriously impatient, so we may jump in and start talking if you don't pause immediately, but we do at least try to give you some indication that we're about to jump in with a question. So with that, I think that is all I need to tell you. Do you have any questions about the process here today?
I don't think so, Your Honor. I hope, if that was directed at me, I don't think so. I think I'm ready to go.
Wonderful.
Whenever the court is.
Wonderful. All right. Well, we are ready to hear your argument. Mr. McIntyre, the floor is yours.
Very well. Good morning, Your Honors, and may it please the court. My name is Jack McIntyre, as you know, and I represent the appellant in this case. We do have a limited amount of time. Our clock is ticking, so I'd like to go ahead and jump right into what I think is the crux of this case, and that is the alibi notice statute. It's codified at 7714-2, and it has some requirements. It requires the defense to disclose to the prosecution its intention to claim alibi, and to tell them what that we have witnesses and who they are, and that sort of thing. But it also requires the prosecution within 5 days to respond to that notice of alibi defense. And what they're required to respond with is the name and addresses of any witnesses that they're going to use to rebut or refute that alibi. In this particular case, that didn't happen. In fact, they ignored it completely, and there's no dispute in this case that they did not respond to that notice of alibi defense. And in fact, what happened was the prosecution simply argued on the morning of trial, when we objected to calling any witnesses to refute that alibi. They simply objected and said, hey, the dates were all in the police report that we already gave them. But that's not what the statute requires. Did Your Honor have a question? I heard something. I didn't see a wave, but
I do, actually, although I didn't wave before.
That's okay.
What is our standard of review here? And I'm looking specifically at subsection 3 of the statute that uses the word may. That's a permissive word. If the prosecuting attorney fails to comply with the requirements of this section, and you argue that they have, the court may exclude evidence. But that seems to suggest that the court doesn't have to. And I draw a contrast, having practiced in the civil world for a while, with the civil discovery rules, especially the new Rule 26D4, I think it is, that actually says if this isn't complied with, the court shall exclude the evidence unless good cause or harmlessness. This is set up in a much more permissive way. And I guess I wonder if you have thoughts on that. whether that should signal to us that we review this for sort of an abuse of discretion, or whether that signals something else.
Well,
Mr. McIntyre, before you begin, I am likewise interested in the may that appears in the very next subsection, subsection 4. We've got kind of a double may here. We've got the may that Judge Harris referred to, and then we've got the may that entitles the court in an appropriate case to waive the requirements of the statute. So perhaps it would be most convenient for you to address the double mays and the resulting standard of review.
Let me take a stab at that, if I may. It seems to me, and I think we did put in the brief, that there is a standard of review, and there's also some case law on the subject, and it talks about both an abuse of discretion, but also prejudice and surprise. So it seems to me that the court certainly can waive those requirements, but it has to have good cause to do it, and the statute also says that. And I don't think that means, well, you complied with Rule 16, and so that's good cause. And let me tell you why, at least in my view, that statute exists, because if Rule 16 is sufficient, we wouldn't even have that statute. It seems to me that the requirement to respond to a notice of alibi defense is designed for exactly what happened in this case. Because what happens in this case, and I hope I'm answering this question, is you get the police reports, you get the dates as they argued, and you get witness interviews and all of those kinds of things. And then as the case progresses along, things change. And in this particular case, the key witness, R.W., changes her testimony. And you would never know that as defense counsel by reading the police reports or any of those things. So it seems to me the statute says may waive it for good cause in both of those cases, and I agree with that. But it also says the prosecutor shall respond to this with these names, seeming, and as our case law talks about, says to avoid unfair surprise or prejudice to the defense. And it's not disputed here. The defendant did his part. It's the prosecutor that let us down on that. So I don't want to get off track, Judge Harris. If I'm not answering your question, I want to be able to answer it.
Well, I appreciate that, Mr. McIntyre, and I think you are answering it to some degree, but there's a little flavor of it that maybe you're missing my question, or maybe I didn't articulate it well enough. It seems like, as Judge Orm points out, there are two mays in the statute. One is in subsection 3 that talks about what the remedy is if somebody doesn't follow subsection 1. The remedy is the court may exclude evidence. And then we have this other subsection, subsection 4, that says the court can waive the whole thing if good cause is shown. And I wonder if those two mays are different, or if we just should collapse both of those mays into a good cause exception. It seems like it's a very strangely worded statute in that we have these two different mays here that aren't. Should we read them separately? That even if there isn't good cause shown, the court still has discretion as to whether or not to exclude evidence in a particular case.
I would say, and if you're going to talk about the two different mays, let me focus on those, because I think maybe I did miss the point there a little bit, and I don't want to do that. When it says the court may exclude the evidence, I think that depends on what that evidence is. And I think that when you say, okay, we're going to exclude this evidence, that should be based on surprise and whether or not, what, if any, level of compliance there may be. In terms of may waive the whole requirements, that could have different meaning depending upon what happened. And it seems like there's a case we cited where they swapped a witness. I mean, the concept was the same, but they had one witness that wasn't available, and I can give the court the citation to that. I want to say, yeah, it was the Ortiz case. And the court said, hey, look, we're going to waive the requirement here because you had two witnesses to it. They disclosed one, that witness became unavailable, but the other witness was available. So you weren't surprised by it because the testimony would have been the same. So I think you could put two different requirements in there, but I think it's going to be case specific.
So it sounds like what you're advocating for is that the may exclude evidence in subsection 3 would depend on whether there's prejudice to the defendant. Is that? Oh, right. Here, as I understand it, only two witnesses testified that he was on the bus that day, the victim and RW. Is that right?
That is correct, Your Honor, and that's why RW was so surprising and so prejudicial to the defendant, because she had no knowledge as far as anything that was disclosed in the police reports. Or, in fact, we even when we sent our detective up to interview witnesses, we didn't interview her because she didn't seem to have anything that would be relevant. So when you have that kind of a change, I think that's what triggers the continuing duty to disclose on the prosecutor, because we had no way in the world of knowing that change in testimony, and we were required to be informed of it because she was a rebuttal witness to our notice of alibi.
So, but just to separate those out, you're not arguing that you were prejudiced in any way because the victim testified that he was on the bus that day. It's just RW, is that right?
That's an interesting question, because as a technical matter under the statute, I guess the victim would have been a rebuttal witness to our alibi for sure, because she was going to testify that it happened to her on the bus. I have to admit, though, that's not very surprising. I mean, that doesn't surprise me at all. We could glean that from what we had. So
here's my problem with the RW, because I agree with you that you may have a good prejudice argument there, since there was no indication in the discovery that she was going to testify that he was on the bus that day. What do we do with the record that we have that's unintelligible, where we can't tell what your objection was or what the prosecutor said or really what the district court ruled? I mean, how do we know that you even raised the objection, that you had been prejudiced because you didn't have notice that of RW's changed testimony before the moment she testified?
Well, I think what you can do two things with that. There's a part of it that is intelligible, and I think it can give us at least a hint. And I can't reconstruct that any better than this court can. It's simply didn't get caught by the mic. But I do think, at least in my view, I think we raised it adequately right up front, because we couldn't have known what she was going to say until it happened, and that's apparent as of that morning. Because we had no idea that she was going to testify to anything having to do with an alibi. And that's kind of a strategic decision. I mean, I don't think I'm entitled as counsel to know every single thing my opponent might do, but I am entitled to know those things that are required by statute. And so it seems to me that the remedy almost has to be either exclusion or, at this point, perhaps even dismissal. And it's not whether it's intentional. It seems to me that that's a fatal mistake that is both surprising and prejudicial to the defendant. Go ahead, Your Honor.
Yeah,
and I'm out of time, but I understand. I guess I can keep going.
Yes.
Okay.
This is bonus time if we keep asking you questions. So I appreciate your patience with us. I just want to ask you, does it matter that the alibi issue in this case just happens to be something that the state was going to have to prove anyway in order to prove their case in chief? What I mean by that is the state had to prove, in order to win the case, regardless of whether there was an alibi defense or not, that your client was on the bus on the date in question, right? That has to be something that they're going to prove. Your alibi defense wasn't, oh, he was at the mall instead, and you had a bunch of witnesses that saw him at the mall, and they were going to cross those people. And, that would be, sometimes an alibi defense raises a tangential issue. The alibi defense here didn't raise a tangential issue, and all the witnesses in question here were witnesses the state had already disclosed in terms of needing them to prove their case in chief, namely that he was on the bus that day and did the things that he was accused of doing. And so I guess I wonder if that matters, right? If the state doesn't respond to your alibi request, to your alibi notice under the alibi statute, is that somehow a way that you can then prevent the state from calling the witnesses they were going to call anyway in an attempt to prove their case in chief? There just seems like there's some push and pull here that I'd like to discuss.
Yeah, and look, I think we should do that, because that's an angle I hadn't thought of until Your Honor brought it up. But I'd like to discuss that. It seems to me that if the statute requires a response and we don't get a response, then it seems to me that that's mandatory. So you ought to exclude that witness, even if the witness was disclosed. That's the argument. In this particular case, though, RW wasn't disclosed. So if it matters in this case, No, because RW appears nowhere as having any relevant information, including in the supplemental report that he talks about up front on the morning of. Oh, go ahead.
But RW was disclosed in the police reports. That's you knew about RW because you had even a transcript of RW's initial interview with the police. I mean, you knew about RW, you knew her contact information, you knew what you thought she was going to say. She was disclosed. The issue you're raising now is, well, we didn't know she was going to change her testimony, and as the state argues, that seems to be a little bit different objection as to whether she was disclosed, right? So,
well, that's exactly right. I mean, what I mean by not disclosed is not being disclosed as a witness that can put D.A.T. on the bus. That's what's required. That's what we're entitled to prepare for. If she wants to testify that she saw him on the bus, like the transcript said 3 months ago, yeah, I'm not gonna go argue with that. It doesn't help them and it doesn't hurt me. So I'm not gonna. But I was entitled to have her disclosed as a rebuttal witness to the alibi defense. And I think I'm entitled to count on, if you don't comply with that statute and you have a witness that's going to put D.A.T. on the bus, I think I'm entitled to rely on that statute for the proposition that you don't get to use them.
If RW was not, if the changed testimony was not disclosed until RW testified, I think you may have a good argument for prejudice, and I don't know exactly if that's because it's a violation of the discovery rules or because of the alibi statute. But how do we know on this record that her testimony was not disclosed before then?
Because the record.
The government, I mean, and the small parts of the transcript that are available to us seem to suggest that there was some indication this morning. I mean, that's what we can hear you say, that may have been disclosed, but without knowing when it was disclosed and also when the government learned of the changed testimony. I mean, it seems to me that whether the government promptly disclosed that is going to depend on whether they learned it in doing a witness interview the day before with RW, and whether they disclosed it promptly the next morning, as opposed to, did they know about it 2 months ago and never disclosed it? And I'm just having trouble figuring those types of facts out based on this record.
I think I can help with a part of that. Part of it is, I think if you look at, I mean, how do we know it wasn't disclosed? Well, you typically would file and serve a notice of alibi defense. I don't think that's really your question. But when he issues the subpoena for RW, I think on this record, we can at least presume that the prosecutor is issuing that subpoena for a reason. And it's the reason for the testimony that he elicited at trial. So if that's the case, he knew about it weeks before. Otherwise, why would he have issued the subpoena to begin with? You wouldn't issue a subpoena for a witness you're not going to use, and he didn't use her for any other purpose. So I think from that record, you can say they knew about it prior than the night before, because they issued the subpoena. Now, in terms of the unintelligible record, when we're talking about this morning, are we talking about a disclosure? Because there's no evidence in the record of that. And quite frankly, it didn't happen in my view, and I was trial counsel. I understand that's not in the record. But from the record, you could also say we're talking about the objection this morning, as well as a purported disclosure. And that's why it's so shocking. And the other thing we can talk about is, when the witness testified, hey, the prosecutor told me all these things. I mean, can't imagine that would have been the night before, especially when the subpoena was issued weeks before. So that's how we know that they knew about it beforehand. I'd probably, to be candid, if he'd have just, I'm not going to hold someone's feet to the fire to that shall within 5 days part of the statute. We accommodate each other as trial counsel on that kind of stuff all the time. But I don't think that if it had been disclosed at the morning, we would have wanted to send out our private detective to go interview those witnesses. And our record is clear. We did our due diligence on every witness that we were aware of.
How do we deal with the issue that no continuance was requested to deal with this issue?
Well, that's the problem. No continuance was requested because we didn't know it was going to happen until that witness testified. And at that point, and you can tell from the record, the judge says, well, you cross-examined her, and so, that's good enough. You impeached her with this. And and as I was preparing, I thought about, well, should we have done that? Well, that's what you're left with when you lose an objection and you don't know what that witness is going to say because they weren't disclosed as an alibi witness. So you don't even get the opportunity to ask for that continuance because the witness is testified by the time you get there. So I didn't ask for that because I wasn't aware of the need. So if that's an answer to your question, I feel like I went off the rails a little bit there. So I want to make sure I'm adequately
No, that answered
responding to
my
the question.
questions. Let me see if there's any more questions from the panel. It doesn't appear to be. So you will have your full time on rebuttal. We have kept you over, obviously, answering questions.
Right. Well, thank you, Your Honor.
Thank you. Ms. Leonard.
May it please the court and counsel, Chris Leonard for the state. The notice of alibi statute is a statute involving or focusing on the provision of notice. And the case law establishes that if you have actual or implied notice of the alibi evidence and an opportunity to investigate, then the trial court has a basis on it which it can decide that for good cause it can waive the technical requirements of that statute, which includes the response by the prosecutor. And in this case, the discovery disclosures made by the prosecutor provided the necessary information, and there was ample opportunity, more than 8 weeks, to investigate, so that the trial court's exercise of its discretion under the statute in finding good cause to waive the response requirement was adequately supported. Now, as Judge Harris points out, the witnesses are necessarily going to be talking about the 28th. And the 28th is the alibi date. So when you're talking about dates, you may also be talking about alibis. So anyone who's being questioned by the prosecutor about what happened on the 28th may say something or articulate something that is likely to affect defendant's alibi for why he claims he wasn't there and why they're saying he was there. I think the idea that some of the witnesses in the discovery disclosure, it was clear that they were going to talk about the 28th, maybe not specifically what they were going to say. I think that's enough. The statute does not require that the prosecutor disclose the content of the information of the anticipated alibi testimony. So the idea that these witnesses that they disclosed might be discussing the 28th should be enough to require the defense counsel to conduct his investigation, given the amount of time he had. Now, in this case, we had a very limited number of witnesses. We had 12 disclosed. Defendant could very easily have excluded 4 of those witnesses because they were himself and his mother, and 2 other witnesses who had absolutely nothing to do with anything going on in this case. And that was clear from the information the prosecution provided.
But there was no indication in the discovery that RW was going to put him on the bus on the 28th. Do you believe that the prosecution had a duty to disclose that? And I understand your argument that the prosecution did disclose it before trial started, but did they have a duty to do that?
The duty, if the discovery did not disclose what was necessary, the prosecutor's duty does not arise until the testimony changes. And the prosecution then has a duty to inform defense counsel about that change. But the problem here is pervasive. We do not have a record that allows us to know when that testimony changed, and therefore when the prosecution's duty arose, nor do we know whether the prosecution fulfilled that duty. It could have happened at any possible time. Right now, all we know from this record is that the testimony changed when RW was speaking to the prosecutor. That's all we know. Now, that could have happened in any of 3 different alternatives so far as I can determine from this record. It could have happened as the state interpreted the unintelligible colloquy. The state interpreted that as suggesting that they had discussed things during their pre-hearing prep. That's a possibility. It's totally appropriate, and but it's not established under this record because there are other alternatives. It could have happened before that. It could have happened after that. Defendant argues that it happened before that because of the issuance of a subpoena for the witness. But the state could have issued a subpoena in pure anticipation without knowing exactly why it was going to use it. The state could have issued a subpoena because the testimony of the witness was helpful to supporting the credibility of the victim, in that the witness was able to articulate that she had seen the victim and the defendant on the bus at the same time, not necessarily on the 28th, but at the same time, and that at or right after the Wellington stop, that she had seen the defendant stand up and walk back to sit near the victim. I mean, it's a tangential type benefit or credibility benefit, but it's still possible. So it doesn't demonstrate that the testimony changed before that. And the testimony
So,
could have.
I'm sorry, let me jump in really quick because I'm not clear on this. I took it from your brief that you were conceding that the prosecutor knew before RW testified that she was going to testify that he was on the bus on the 28th. Is that not the case? Are you saying that there is a reading of this record where perhaps the prosecutor didn't know until she testified that the testimony was going to change?
No, I am conceding that, but what I'm trying to point out is that the prosecutor might not have known until right before the testimony, because the conversation between the witness and the prosecutor could have been in person, could have been by phone. There were 3 recesses before she testified that day, once the hearing started, and at any one of those recesses, they could have spoken. And at that point, the prosecutor may very well have found out there's going to be a change in testimony. And as far as this record goes, the prosecutor could have told defense counsel, and the record doesn't show that.
But you agree that at that point, whatever point it was, that the state found out that her testimony was going to change, the prosecutor did have a duty to inform defense counsel.
If in fact the discovery disclosures initially was not enough, if this court finds that wasn't enough to inform the defendant that she could be an alibi witness, then yes, the duty for the prosecution arose then when it did decide or discover that she could be an alibi witness.
And because the record is silent on when it was discovered and when or if it was disclosed, your argument is that that cuts against the defendant who has the burden on appeal.
It absolutely cuts against defendant. If the record, if an objection had been made specifically to her testimony, when we know that defense counsel knew when she testified on direct examination, at that point, all bets are off. Defense counsel knows she's now an alibi witness. If he had objected at that point, we could have created the record. It would have been here for us, assuming that it was able to be transcribed. Or he could have conditionally objected and said, you know, I didn't know about this. I'm surprised. I need to find out what she's going to say in order to address the court with whether this is prejudicial to me or not. He did nothing. What he did was choose to address it.
Here's my question about the silence in the record. I mean, we know what the government's pretrial disclosures were. I mean, we know what the discovery was, and we know that the testimony changed. So in that situation, is that enough for a defendant to point to the disclosure saying, we did not receive this information? Is there some kind of burden shifting that happens where the government then needs to put on the record that, in fact, even though it was not in the original discovery, it was properly disclosed to the defense before the witness testified?
I don't think there is a shifting of burden. The statute is a discretionary statute, and the yardstick by which you determine whether the trial court did or did not abuse its discretion is whether defendant did or did not suffer unfair surprise or prejudice. That's what defendant needs to establish. And he has to establish that there was a violation that caused him the unfair surprise or prejudice. And there may well have been no violation here. If there was a violation, then maybe he was prejudiced, but he's got to establish that. And he hasn't made the record he could have made below to establish that, to meet that burden. And the fact that he didn't object when she testified, Judge Harris.
On that point, I guess I'm a little unclear about this too as well after listening to some of the argument today is, do we even have a record that there was an objection at all made with regard to unfair surprise regarding RW's testimony? I mean, the objection that was raised during the officer's testimony was an objection to, hey, you didn't comply with the alibi statute, which would have given us names and addresses and contact information and such and so forth. But that objection was made while the officer was testifying. And during the course of that colloquy, I didn't read any there wasn't any, that I could tell, any objection about unfair surprise or changed testimony. And then we have the objection that was made during RW's when she got back up for a redirect, but that's unintelligible. We don't know what the objection even was. So maybe this is sort of a softball for you, and Mr. McIntyre, maybe you can address this on rebuttal. But what record do we have that there was even ever an objection made as to changed testimony and unfair surprise?
We don't have an express record, but what we have is the logic that if in fact her testimony, and we don't know, changed before he made that objection, it had to have changed before then in order for that objection to have encompassed, to have even possibly encompassed her change in testimony. The idea that he should have then had a duty to disclose that she was now an alibi witness. That her testimony then must have changed before he made that objection, or you can't even begin to assume that that objection covered her change in testimony. So no, the objection as it stands and the record as it stands suggests that when she objected, that first objection during Judd's testimony, it was simply a matter of he didn't do what the statute requires. He didn't file it timely, and he shouldn't be allowed then to have any of his witnesses testify. And the fact that the unintelligible sidebar doesn't give us any indication whether there was a specific objection under subsection 2 and the duty to disclose the changed or the additional witness keeps us from determining that he made a proper objection then. And the bottom line is that it depends on when her testimony changed, whether you can interpret his first objection to include that or not. And we don't know that.
I agree with that, but on the second objection, the only thing that we really know, it seems to me, is that this objection had to do with being ambushed, because that's what the district court said, right? Mm-hmm. Is that enough to preserve this issue? Let's just assume that the only objection that was made is we were ambushed by this testimony because we didn't know she was going to testify in this manner. Is that enough to preserve the objection for our review?
If in fact that were the objection, that might be enough. But we don't know that that was the objection. It could have been a Rule 16 objection and still been phrased that same way, that we were surprised. He should have had a continuing duty to disclose and he didn't disclose. That could have been all it was. We don't know. We need to know more about the objection. And the fact that he didn't object when he heard the testimony suggests he was not surprised. He was ready to meet it. And he completed his cross-examination, allowed the redirect to start before he decided to call for a sidebar and object. That suggests that maybe something in her testimony, once he crossed her, that maybe she came across more credible than he expected, and so he thought, well, maybe I better stop and try to get rid of the testimony. Something happened maybe that changed his mind and made him decide, oh, no, I'm going to have to do more than simply meet it the way I had planned. But it suggests he already knew. He knew about the testimony. He was ready for it. And that's what the trial court basically found. And when the court found that he was not ambushed, he was not, in other words, surprised, in essence, defendant didn't come back and say, now, but if I know I met it on cross, but if I'd had a continuance or if I'd had proper notice, I could have brought this evidence in, or I could have looked into this idea, this way of refuting it or rebutting it. Nothing on that suggests that he did that on that record. He accepted the ruling of not ambushed. He met it. That was it. Went on. I think it indicates that he probably knew about the testimony, but we don't know on this record for sure. We just don't know. And given the fact that we have so many different places, so many different ways in which the changed testimony or places where it could have occurred, where the duty then for the prosecutor to disclose could have arisen, each one of those alternatives also leaves open the possibility the prosecutor actually complied with his duty. And we just don't have a record that gives us enough information to allow us to reach the issue of whether, or decide whether defendant has established whether he was, or could establish whether he was unfairly surprised or prejudiced by the trial court's ruling. Aside from RW, defendant is also claiming unfair surprise and prejudice because of a change in testimony of the victim and the mom from the discovery documents to the hearing itself. But the statute, the notice of alibi statute, is not a statute that deals with the content of the testimony. It deals with the subject matter, the notice of the testimony, and not the content. So simply a change in the content, change in the content is not enough to violate statute or establish the abuse of discretion in the trial court's ruling below, unless it's a change as he suggests occurred with RW. But we can't, again, decide whether that works or not, whether that was established on this record. If the court has no other questions, the state will submit it on that and ask this court to affirm the trial court's ruling and the adjudication below.
Thank you very much for your argument. Mr. McIntyre, we will hear your rebuttal.
Very well, Your Honor. Let's talk. I'd like to start, I think, with a rule of construction. I think in some ways we're conflating the general mandate of Rule 16 with the specific statute that talks about the notice of alibi defense. And that's pretty specific in what's required. And it seems to me that what the state is doing is trying to dump the burden of their noncompliance on the defendant. And that seems to turn the statute on its ear, in my opinion. It seems relatively clear to me. The other thing I want to talk about.
I'm sorry, let me just ask you about this, because it seems to me that the state is conceding that they did not comply with the alibi statute. That doesn't seem to be an issue. It seems rather whether the district court could have waived the requirement for good cause, or whether the district court in its discretion could have decided not to exclude the evidence. Isn't that the question that we're dealing with? I mean, I don't think there's any question that it was violated.
I think that if that's Your Honor's question, I think that I have a pretty good answer for it. I mean, it seems to me, or at least I'm going to try to have a pretty good answer for it, and that is that. Oh gosh, I've lost my train of thought there for a minute. Could Your Honor repeat that last second sentence? I apologize.
Sure. It seems to me that the state's conceding that they violated the statute. I mean, there's no question that no notice was filed within 5 days stating the people who were going to respond to your notice of alibi. But what the question seems to be is whether either the district court could have waived the notice requirement for good cause, or whether the court in its discretion could have chosen not to exclude the evidence simply because your client didn't suffer any prejudice. Am I framing that right?
I think so, and I certainly don't want to tell Your Honor how to frame anything, but it seems to me that the answer is no. They can't find good cause here simply because the prosecutor complied with Rule 16. There's not good cause there, especially when the judge admits, I didn't even read that report. How could he find good cause? He didn't even know what was in it. There's no good cause at all. And I didn't mean that as a question. I'm saying it's just not possible to accomplish it. There's no good cause. You can't find it because he doesn't know. He was in the same boat defense counsel was. We had no idea what was coming. Now, in terms of preservation, if I've answered Your Honor's question, I don't want to move on.
Just one other question. I will let you make your argument on preservation. So what about the other subsection of the statute where it says that the court may exclude? My understanding of your argument was that that the limits on the court's discretion there is whether the defendant was prejudiced. And how do we know from this record that the defendant was prejudiced? I'm sorry, I'm saying the defendant. Forgive me for the terms.
That's okay. I'm making I've done the same thing here. I think we say it when you look, because there's part of that colloquy on that objection during RW's testimony that's unintelligible for sure, but parts of it are intelligible. It's clear that when we objected, we said, hey, this is an ambush, we're surprised, we're prejudiced, whatever it was we said. But at the end of the day, for the judge to find we were not ambushed, we had to be arguing about surprise or prejudice. There's just no other sensible thing to read into that. So I think it's preserved there too. And again, I think that the state makes the same mistake that the judge made when he responded to that objection, when he says, hey, look, this witness testified, you cross-examined her, you impeached her. Well, it's, in my view, it's not an either or choice, because if that undisclosed witness is surprising, she never should have testified in the first place. So by cross-examining her, that's not a choice. That's what's left over when you lose an objection that you should have won. I hope that answers the question. If I'm getting there, I know I've got a few seconds left, so I just want to make sure. The problem here, well, the statute's mandatory. It says the prosecutor shall file and shall serve. So while the state complains about the absence of a record as to when that notification is made, that's a problem the state caused because they failed to file what they needed to file, and now they want to dump it on defense counsel. Hey, he was notified this time or that time. We shouldn't even have that question, and that's the state's fault. That ought to be laid at their doorstep, not defense counsel's doorstep. And I don't mean that personally in any way. I just mean that's what the statute says, and that's what we ought to go with because it's plain language statute. I don't see it as ambiguous at all. I can see I have 10 seconds left. If there are other questions, I'm up. Judge Harris.
Yeah, again, bonus question doesn't count.
I like bonus questions.
Please answer the question, even though you're out of time.
Okay.
I saw nothing in your reply brief about the second issue you raised in your opening brief, which was this issue about the video camera evidence that didn't get sought and asked for or preserved. The state came back in the red brief and said, "Hey, this issue is controlled by the recent case we issued last year in the Powell case." And should we infer from your not mentioning it in your reply brief that you think the state made a really good argument, or would you like to respond to their argument that Powell controls this case?
Candid, Your Honor, I'm not sure what Powell says, so I can certainly respond to that. But the argument with respect to the videotape in 10 seconds or less, and I can respond with supplemental briefing if the court wants, but the response is no one other than the state, the police officer, had any reason to think of that videotape. He admitted he knew about it. I can't understand why it wasn't retrieved. Not only could it have been exculpatory, it could have been completely dispositive. And no one else would have been in a position to do a darn thing about it. And it seems to me, the way I read Tiedemann, it's a case-by-case analysis. I haven't read Powell, but I'm certainly going to as soon as we're done today.
I thought that the issue, I'm sorry, Judge Harris, go ahead.
No, never mind. Powell says that if the evidence was never in the state's possession to begin with, there's no due process violation merely because the state forgets to ask for it or neglects to ask for it or chooses not to go get that evidence to use it in its case in chief. And that seems to apply here. The state made the decision, we don't need the video evidence, we're not going to ask for it. It's in the possession of the school, not the state, so we just don't have a Tiedemann issue on facts like this. And that argument seems fairly strong to me, and I just wanted to give you an opportunity to respond to it.
That I can respond to, I think, and it's in the D.A.T case, which I am fairly familiar with, when it talks about negligence on the part of a state actor. And in that case, it was a prison case, so clearly there was more control than you would have in like one of our public schools, for example. But what this court was concerned about there was, hey, look, why in the world wouldn't you go grab this evidence when you know something has happened or you know there's an allegation of some type? In this case, Officer Judd admitted that he knew there were cameras. He clearly knew about the allegation. It was reported to him, and he does nothing. To me, that's just flat, unfair, inappropriate, negligent, and by the time anyone else becomes aware of it, it's just too late to do anything about it. And that's my best argument on that point.
I have a slightly different question regarding this same issue. The state also makes the argument that your client never moved never moved to dismiss the case, never cited due process, never made a Tiedemann argument to the district court, and because of that, it's not preserved. What's your response to that question?
Well, let me address that directly. I think that we did address it both in our cross-examination of Officer Judd and in my closing argument.
But did you make some kind of motion that the court could rule on? Because ultimately we have to review the district court's ruling. And did the district court have an opportunity to rule on a due process issue here?
More or less, and I'll tell you exactly what happened. Because at the time we didn't really foresee the appeal, but when the judge comes back and he says, hey, look, I can't rule on evidence I don't have, because we did bring up in detail in our closing the lack of that video, then basically the argument goes like this. If you're going to say I can't rule on evidence I don't have, i.e. the video camera, then don't rule on the evidence you don't have, and don't say your alibi witness lacks any credibility by saying what that camera would have shown. So I guess the best argument now, in light of your Honor's question that I didn't think of before, is if you're going to not rule on evidence you don't have for the prosecution, then don't rule on evidence you don't have for the defense. Just make it the same for both. That would be my response to that. And the only way we preserved it, was in that closing argument, in that colloquy with the judge at the time.
One final question, and this is probably neither here nor there, but from the record, it appears to me that your client will age out of the juvenile court's jurisdiction in 2 weeks. Is that right?
That could very well be right. He's listening in on the phone. I could ask him. I didn't remember his birthday, but I would like to address that because I think that's important for a lot of different reasons. I mean, and quite frankly, we had those discussions when we filed this appeal, and I have to stand firmly in the corner of those juvenile courts. They are the most important courts that we have in the state of Utah, because that's where your replacement is going to come out of the juvenile court if they ever end up there. Our senators, our congressmen, our governors, if the rule of law doesn't matter in the juvenile court, it can't ever matter here. And that, I think, is important, even if he was going to age out of that system tomorrow. Does that answer your Honor's question? I hope it does.
Yes, thank you. I appreciate that. And I see no further questions. We will take this matter under advisement. Ms. Leonard, if you'd like to join us again. I just wanted to thank counsel for the arguments here today. They were very helpful, and we will issue a written opinion as soon as we can. Thank you.
Thank you, Your Honor. It's been a pleasure.
This court is